we get into the actual hearing and what actually happened when Judge opened court. There were so many applications, but the power applications, what I feel is important to mention in this case, is the first one, which is the interlocutory application to strike out the statement of claim. Okay, so the Crown wants to strike out my statement of claim. Okay, and then they had an affidavit in support of that claim. All right, and it's been sworn. This is the Crown's first application that they lodged with the courts. Okay, so this is the very first one, dated 19th of May 2023, and it's called the interlocutory application to strike out statement of claim dated 9th of February 2023. I'm not going to read it. So this is the first application. I'm just going to go through it. And I'm not going to read it, just to show you guys. So with this came the affidavit. Here you go. This came with that same application we just went through. This is the affidavit of Sean Graham Hayward in support of application to strike out statement of claim dated 9th of February 2023, dated 19th of May 2023. That was a day, that date here is the date they filed it with the courts and forwarded it to me. Okay, so I'm not going to read it, we're just going to quickly go through it. These applications were sworn. Okay, this is the actual settlement document that at the mediation. This here is the core evidence of the ministry. Basically, this is their foundation of their case, or the key elements of their case. But I won't read it, we're just going to go through it. And then last day of duty was 29th of December 2015. Okay, so this is from their payroll team. Attached with that are exhibits from mediation. This is my lawyer here, Stephanie Ball, and Catherine Stewart. So it was the employment law specialist, Catherine Stewart law firm, the barristers. So that was my lawyer at this time. Right. It cost me $10,000 for my lawyer's fee. Yeah. So part of the half payment came out of my settlement for the lawyer's fee, but only half of it. The other half I paid myself out of my own pocket. This is the other exhibit that they had in there. Now this letter here I think is really important because I use this as one of my key elements in the case at the oral hearing. So so this is the actual letter dated 10th of May 2016. Okay, this letter was actually evidence. It was one of my strong evidence in my case that I had used also in the Ministry of Health and City Med case. So this letter here, I won't highlight why yet. I'll just go through the evidence that was said, but I'll probably end up coming back to this. Okay, so in this letter, it's dated, let me see, 10th of May 2016, and basically just, yeah, confirmation of my position when I was working for the courts at that time. Keeping in mind it was Department of Courts in 2002, and the title of my role was Deputy Registrar for Jury Trials Depositions. So that was the job title back then. But even though I left there, when you leave different jurisdictions in the court, you take your Deputy Registrar powers with you. And even though the names of the role changes, you still keep your Deputy Registrar powers. So court registry officer is usually, that's just the overall name for everyone, but you know, it takes some time before you can get your powers or your Deputy Registrar powers. You have to actually go through some processes, get sworn for it. It's like when a judge is sworn in, Deputy Registrars are sworn in too before they actually get their powers. And then they've just got to go through all kinds of training and all that before they can actually use them. So this here is just a document. This from my Dan Brady, my manager. Well, his title was Lead Service Delivery Manager for the District Courts, Ministry of Justice. And then attached with that is all the exhibits, but I won't be reading any of it. It's not really relevant, but it is evidence in court. This is just a receipt. Yeah. I submitted evidence of proof of how much was paid to me. It's kind of like, I just went with what was put in my bank account, but $10,000 I had to pay towards, or about almost $10,000 to be exact. It was 9,800 or something from the top of my head. I just saying $10,000 because I'm just rounding it out, but yeah. So this is according to the judge's schedule. After the case management on the 30th of August 2023, we had to follow the judge's schedule. I had to respond to this. This is after doing the interlocutory application to enter summary judgment. So I had to immediately work on the next application to oppose this application. So this is called the first one according to the schedule. Notice of opposition in opposition to plaintiff's application for leave to file application for summary judgment, dated 13th of September 2023. All right, I'm not going to read it because I've already typed this out on the last clip. So you can just go through there. Just trying to cut down time. Okay. So this here is the second application from Crown, but they decided to amend the first from the first notice of opposition in opposition to the plaintiff's application for leave to file application for summary judgment, and this is dated the 19th of September. So they decided to amend, to make a few amendments. I won't read it. We're just going to go through this quickly. It's quite lengthy, really, just so you can get an idea of all the work that entails with what I had to do. Council's last application for court was due on the 11th of October 2023. And so this is their very last application. And so they submitted, this is the Crown's defended submissions in support of interlocutory application for strikeout and in opposition of plaintiff's application for leave to apply for summary judgment, dated 11th of October 2023. Right, so this is theirs. I'm not going to read it. As you can see, it's quite a lot to read. So this is the last application that I had to follow through. Hang on a moment. Just carrying on. Okay, so this is the Crown's last application. I go into court, Crown comes in, we have a brief conversation before the hearing actually opens. I knew that they were going to try and get the application called first, and I was prepared for anything because, I mean, I wasn't happy about it because I knew that my application should be first, but that is what's been happening. They're helping each other. And so with that, the Crown said, me and Mark, we had a conversation, and he suggested how do I feel if they have their application called first. And of course, I just let them know I wasn't, I wasn't happy about it, but I'm lenient. And he goes, well, that's why we have a judge. And then I found out he had a conversation with the judge before the actual hearing without me knowing. And I just, went with it. And I just said to him, well, I'm lenient to whatever the judge says, because, I was ready anyway. So, but I wasn't happy about it because that's not the normal court protocol. The court is open, the judge comes in, and then we have a conversation, and then judge made the decision to hear the Crown's application first, and then he said after that he will hear mine. And so that's how it started, and that's how the court went. What happened was the judge took the hearing all the way back to 2006. Okay, he was going through the statement of claim. Okay, so what I'm just going to go through is the judge took the evidence back to 2006. So what you're seeing right now is one of the affidavits in regards to the breaches that was in the protected disclosure. So I'll quickly just read it. I think this is actually an exhibit in the courts, but this is the affidavit the judge read in court on the 1st of November 2023. Okay, affidavit. Complainant Mina Crichton, Court Officer, Waitakere District Court. This is my affidavit in support of the complainant. I wish to make concerning certain colleagues who have divulged personal information about me without my permission and used that information in ways that are not appropriate. I believe that these colleagues' actions have breached the Privacy Act 1993, Section 6, Principle 1, Principle 3, Bracket 1, A to G, Principle 4, A, B, Principle 5, A, 2 and 3, B, Principle 10, B, D, Principle 11, D, and F. Okay, I probably shouldn't have read all that, but anyway. Okay, number 1, it has been suggested that my concerns stem from my own paranoia, implying that I am imagining things that may not be true. I have substantive evidence that this is not the case. People from outside of work rang in different times and have also made all kinds of accusations about me. For example, that I'm using my position in the court to invite people to church, that I allow my daughter to drive my car with my youngest son in the car, which wasn't true, that everyone at church hates me. The week I went to leave for my son's 21st, when I came in here was another version told. It was suggested that I had lied to my colleagues about it. So basically I'm just set down in the affidavit, just gossip and rumours that were going around at this point of time. But this here was in the protected disclosure. Basically, I drafted this up as proof that, my suspicion in the first instance that there was breaches and somebody was leaking personal information about my work activity from home to my private life, which at that time was the church. All right, so this is what this affidavit is about. Number 3, there has been gossip about me in regards to my personal life and my church activities. One day I was on the phone talking to one of my elders at church. And in our conversation, he asked me questions in regards to murder cases and how the court operates. Someone picked up the phone on the other end and listened to my conversation. I have reason to believe that these are the sort of accusations that has caused an investigation by management and police. I was never informed of the investigation or the outcome of it. Now, at this point of time, some of the staff, that's also in the union and in the MOJ evidence, had complained about somebody at work was actually listening in to their private conversation. So this is the kind of problem that the staff were having, that they had reason to believe maybe somebody within the ministry, I don't know who was doing it, but they were tapping into our private conversation at work. So I was a PSA delegate, and these are the kind of complaints other staff were complaining about and concerned about, because we're all entitled to our private conversation. However, when I was working on my break, I would, the odd time, speak to the elders of the church, because I was close mainly to Pastor King, and speak to other people, on our breaks, because we're allowed to. We all had suspicion someone was listening into our private conversation, which I knew as a PSA delegate was illegal. There was no reason for it. But these are the kind of things the staff, while working for our employer, Ministry of Justice, were all complaining and concerned about. And I actually brought that up with management, but they all denied it. But there were staff that witnessed the same problem. But these are the things, the gossip and the rumours that I had suspected. And, they were actually privacy breaches turning into gossip. And so that's what was going on at work. Now, that conversation I had with this particular elder at the church was just a normal conversation. He had asked me what kind of job I did, and I just basically gave him a bit of a job description. I didn't mention any privacy, like any names of the court or of the parties or a case. Nothing like that was discussed. Just basically gave him a view of background of the kind of work I did. It was just a normal conversation, had nothing, no disclosure of anybody's private case or anything like that. But the concerning point was we knew somebody was listening in our private conversation at work. And I was also concerned about the hacking and the proxy hacking into our emails while working. It wasn't just that, it was also just other concerns where we felt, something's not right. That was all that information. There were emails to support some of the staff complaints to confirm that my suspicion was exactly like theirs. All right, continuing. The sort of information about me released to the public are as follows: that my work performance is not good and that my job is on the line. There is an investigation on me, that I gamble, lotto, I had taken the flu injection. These people, outside my workplace also know whether I am at work, on sick leave or annual leave. So I'm complaining about the harassment, public harassment, work harassment, and the passing on information. I was being exploited. And I knew it. So I didn't know what else to do, but I wanted it to stop. So I drafted this up, and I had supporting evidence of emails of other staff complaining about the same thing. The other issue we had at the workplace, I had a suspicion that staff were being used to ask me questions and recording. I had like some kind of investigation, it was just the way I was, they were asking me questions. I was like, where'd that come from, kind of thing. So I had that suspicion, and I had that in a protected disclosure, that I had a suspicion that some of the staff were illegally having private conversations with me and recording without my consent. Okay. Number 6, I have reason to believe that the people outside of work have been ringing in on a regular basis over the last couple of months, 4 to 5 months, maybe more. My greatest disappointment is that no one in management have approached me about any of these accusations. I have reason to believe, because these incidents have been ongoing, the gossip at work has affected the way my colleagues think towards me, for example. So basically the gossip, the defamation that was going on secretly was an alliance was definitely building up. I was left out of emails. I have sent our emails to my team leader and no one responded. I've been left out of training and other office activities when I would have otherwise be fully involved. So these are all the things that slowly started to happen at work. Definitely an alliance, a bully alliance had built up and at work, and they were starting to bully and interfere with my work. Just different things happening at work that I knew was they were setting me up. I would go into work. Some days were worse than others, and they would set me up to fail, is the word. But I just persevered and did the best that I could, and I believe I did pretty well. But this went on, I'd say, by 2008. Everything was kind of dangerous for me because of the harassment and just the stalking was happening, harassment in the workplace. Which was consistent when I went home. So that's how it was for me. There have been a serious emotional impact on me through the excessive stress that I have had to endure. I have a medical report from my doctor that assures me that what I'm experiencing is not my own paranoia, but that I'm suffering the effects of excessive workplace stress, and the opinion of the doctor do not require a referral to a psychologist or any related medical treatment, and my condition would improve significantly once the causes of my workplace stress are removed from me. I can reduce the medical report on request. Number 9, I feel I have been treated unfairly. I feel that the actions of the staff members who have invaded my privacy have seriously damaged my reputation and has implied that I am no longer a person of integrity and whose conduct is unbecoming of an officer of the court. So an alliance had clearly was building up. By 2008, it just got worse. Okay, so number 10, in spite of the gossip and accusations that have been levelled at me, mostly behind my back, I believe that my conduct and performance as a court officer is beyond reproach. It is the conduct of these staff members which is inconsistent with the ministry code of conduct and therefore should be dealt with accordingly. I declare this statement is true to... Right. And so he was just asking me questions, and then he kind of went through